Call our next case, see Gregory David Wood, Executor versus PERAZA and Infante.
May it please the Court, I'm William Ball. I represent the plaintiff, Gregory Wood, who is the personal representative of the estate of his mother, who was killed in an accident in 1999. I know the Court's probably familiar with the course of events from the briefs, but let me recap them briefly. The case gets filed in 2001.
Counsel, do you want to reserve some time for rebuttal?
Yes, I'm sorry. I'd like to reserve 8 minutes, if I might. Thank you, Your Honor. Case gets filed in 2001 against 4 defendants, really essentially 2 defendants. The accident was caused when a tow truck merged onto the interstate, struck a semi. Semi goes across the median and hits the vehicle in which the decedent is riding. The case is filed against the drivers of the 2 vehicles and the owners of the 2 vehicles. In 2004, all of the defendants amend their answers, which had previously asserted 768-81 defenses, withdraw those defenses, admit liability, and also file a stipulation in which they stipulate that they're jointly and severally liable for all damages. The case then proceeds for another 3 years, during which there are several hearings and motions directed to the issue of what evidence of the accident, if any, is going to be heard by the jury. The plaintiff was taking the position, understanding that liability was no longer an issue. The plaintiff was arguing that the survivors' damages, their mental suffering, was to some degree influenced by the way the accident happened, and that the jury ought to know something about how the accident happened. The defense was arguing very vigorously that little or no evidence of the accident scenario should have been admitted. So that goes on for 3 years, and the case is set for trial in early 2007. Shortly before trial, we settle with the tow truck company and the driver of the tow truck for $630,000. The remaining defendants, PERAZA and Infante, then do 2 things. First, they move for a continuance, and they seek to withdraw their amended answers and go back to their original answers, in which they asserted comparative fault defenses. And they take the position before the trial judge that there would have to be a set-off of the settlement if they are not permitted to amend their answers. The judge denies the motion for continuance, but indicates his intention to grant a set-off. We then have a jury selection. Plaintiff moves for...
Was there any objection below by your client's attorneys to that indication that, okay, I'm going to go forward and have the trial with the stipulation, but I'm going to set off damages against the settlement? Yes,
Your Honor, there was, and I believe these excerpts are quoted in our briefs. Mr. Pajic, representing the plaintiff, said several times that we intended to raise the propriety of set-off post-trial, and we did not stipulate, would not agree that there would be a set-off. And we took the position then, and we've taken the position throughout, that that would be a matter for post-trial determination by the judge. Interestingly, contrary to the defense position, which is essentially that we made an election by refusing to stipulate to a set-off, the trial judge never took that position. The trial judge in March, after there was a mistrial declared in the first trial, they renewed their motion for continuance. I was at that hearing, and the judge denied it again, and we again preserved our argument for post-trial that the set-off would be improper, and the judge indicated that he would hear it then. Even in his order, the way he describes his earlier announcement of intent is that he indicated that he may grant a set-off. And so I would say, Your Honor, it's clear from the record that throughout we took the position that we were going to argue against the set-off post-trial. So there is a trial in May. There's a $900,000 verdict. The issue then becomes, what do we do with a $630,000 settlement? Plaintiffs took the position that the case was right on point.
Do you think it would have been within the trial judge's discretion to make you or force you to make an election?
No.
Okay, we have an option here. The defendants are in a different position than they were. They'll be prejudiced if they have to go forward under these circumstances. I'm going to allow the amendment. If you need additional time for discovery to prepare to prove liability, then I can continue the case. Or if you want to go to trial today or within 4 days, whatever it was, then you're going to have to live with the stipulation as well, and they get a set-off. Would that have been within the trial judge's discretion?
I don't think so. I think we made our position clear that we were not agreeing to the set-off. I think the judge then has to either let them amend and continue the case or not, and the judge didn't. I don't think it's proper for the judge to
you objected to the continuance, though. You objected.
We did.
You objected to the continuance.
Correct.
You objected to the amendment of the pleadings.
Yes, we did.
And you objected to any set-off.
Correct.
All right, let me ask you, if the judge had ruled your way on those issues, would you agree that the appellee would be in worse situation than he had prior to the settlement between you and the other defendant?
He might be, but it was not an unforeseeable situation.
Well, because here's what concerns me, is that you enter an agreement with the other defendant, and as a result of that agreement, there's a substantial change in circumstances in the trial dynamics. The appellee was not part of that settlement, and if the trial judge accepts your argument, then the appellee is in it seems to me, much worse position, and you're in better position because of the changed circumstances, even though the appellee wasn't part of the changed circumstances and you were.
But, Your Honor, we were not a party to the original agreement between the defendants. In fact, we didn't even know what the agreement was. We just knew they had amended their pleadings. We had proceeded for 3 years, and we knew about that agreement when we settled the case. I think we had a right to think that the admission of liability and the waiver of comparative fault defenses were going to control.
In one place in your brief, you say if the appellee's got a complaint, it's against the other defendant.
What we're saying is that
is that?
Yes, I think it is, because...
Do you think that the appellee has a cause of action against the other defendant?
I'm not sure. I don't know. I do know this, that the possibility of settlement by one faction of the defense or another was clearly known by everybody when they made their agreement in 2004. And if they wanted to specify between themselves what would happen in that event, they could have done so. They could have, for instance, had an indemnity provision that says if one of us settles and the other one ends up paying more than its 40% or 60%, as the case may be, the other one has to make it whole. That was a private agreement between them, which we had nothing to do with. So, yes, I think they could have anticipated it, and I don't think it was our action that put them in a worse position. We just settled a case with some of the defendants, as happens all the time.
Counselor, when you did go to trial, was the jury asked to award the totality of damages that your clients suffered as a result of the accident?
Yes.
So the jury figured out that the total amount of damages that your client suffered, or your clients suffered, was $900,000.
Yes.
They already had $600,000. So what's the social policy that would encourage your client to get $1.5 million out of a case which a jury has determined is only worth $900,000?
Your Honor, that question is precisely addressed in Wells, and I'll tell you what the Supreme Court says the policy is, and the Supreme Court says that settlement dollars and verdict dollars are two different things, and in every case in which you disallow a set-off, you have the potential for exactly that happening. It happened in Wells. The plaintiff in Wells recovered more than the damages awarded by the jury if you add back in the settlement amount. So the policy is, I would suggest, is fostering settlements, and the recognition that when you settle with a party, it's it's a assessment by both sides of what the potential risks are, and it's apples and oranges to add that to the verdict. Let me move to D'Angelo, because, and I may want to leave a little less time for rebuttal because I haven't even talked about D'Angelo yet. We think this case is absolutely indistinguishable from D'Angelo. D'Angelo says if you make a tactical choice not to assert your rights under 768-81, you do not get a set-off against for non-economic damages.
Well, wasn't the appellee's tactical decision that they wanted apportionment on the verdict form, and you objected? And D'Angelo, it's the opposite. They did not want apportionment on the jury verdict form.
That was their tactical decision after the settlement for in 2004, when they amended their answer and admitted liability and withdrew their comparative fault defenses. That was a tactical decision, and that tactical decision governed the course of the litigation for 3 years. To say that after that we can suddenly wipe all that away and go back to a case in which liability is contested, in which comparative fault is contested, that materially prejudices us because people's memories fade. You can't say you can just reconstitute a case after 3 years. How are you prejudiced? You're prejudiced because you...
how is your client prejudiced in this case? The jury found that your three clients suffered $900,000 of damages. You're going to get $900,000 of recovery. How is your client prejudiced by the trial court's decision?
Well, I think they're prejudiced in that the law of Florida, as plainly stated by the Supreme Court, hasn't been followed, Your Honor. The Supreme Court in Wells, I repeat, let the rule that the plaintiff was entitled to recover more by settlement and verdict than the amount of the verdict. And that was followed through in D'Angelo. And this case is not different from D'Angelo. D'Angelo, once the doctor settled and the hospital elected not to pursue its comparative fault defense, the hospital was going to, in essence, going to be jointly liable for any damages that a jury might have attributed to the doctor. It's all, D'Angelo also, and I'm going to run over and I'll take a little less time on rebuttal.
That's fine.
D'Angelo also, in my view, although not specifically, not expressly, answers another defense contention, which is that somehow by recognizing the state of the pleadings and by entering into a pretrial stipulation and submitting a proposed verdict that recognizes the state of the pleadings, we somehow were a joint participant in the defense decision to withdraw its answer and withdraw its comparative fault defenses. And it's interesting, the trial judge, Judge Traynor, did not find this case, he explicitly did not find this case sufficiently distinguishable from D'Angelo to allow the set-off. The sole basis of the order that's articulated by Judge Traynor is this supposed participation by the plaintiff. I would suggest that the plaintiff has no right to make a defendant plead an affirmative defense. When the answers were amended in 2004, what do we do? Object and say you can't do that? The same thing could be said in D'Angelo, that the plaintiff should have made the hospital put the doctor on the verdict. It's not discussed, but that possibility was there too. So that is not a basis for distinguishing the case. And I go back to, again, the court seems to be concerned with why are we allowed to recover $900,000 or more than $900,000. I would respectfully submit that that's exactly the result that the Supreme Court of this state has sanctioned in Wells and D'Angelo. That's what's going to happen when you deny a set-off. And it all goes back to the change in the law on joint and several liability for non-economic damages. And D'Angelo says there's really only one way you can avoid paying the full amount of those damages, and that's to follow Nash, which says you've got to put them on the verdict. I'll reserve the rest of my time. Thank you.
All right.
May it please the Court, My name is Bill Stone. I represented the defendants in the trial, Mr. PERAZA and Mr. Infante, and the appellees here. I think one thing we can agree upon is there has always been a system in these cases, both before and after the amendment to 768.813 that did away with joint and several liability for non-economic damages. There's always been some sort of system in place where defendants were not required to essentially pay more than their fair share. Before,
how do you explain Wells and D'Angelo?
Oh, I think, Judge, if you read both of those cases, in fact, I disagree with counsel's comment about D'Angelo. If you read every one of those cases, Wells, the other case that we cite, not Nash, but the other Supreme Court case, Gowdy and D'Angelo, they all recognize and continue to say that set-offs may be appropriate, and those set-off statutes are still on the books, and they may be appropriate in certain situations. I'm looking at D'Angelo right here where they're citing from Gowdy. We conclude, following our reasoning in Wells, that the applicability of the set-off statutes is predicated on the existence of other tortfeasors who are liable for the same injury as the settling party, i.e. joint tortfeasors. You will find that kind of verbiage in all three of those Supreme Court cases. So D'Angelo did not adopt this black and white all or nothing rule that counsel suggests. We have always had something. Before they changed the statute and did away with joint and several liability for non-economic damages, what would typically happen is if a settling defendant settles, there's a set-off for that. That's the way the law worked, and those set-off statutes are still very much on the books. Then you have the amendments, 768.81 sub 3, which changes the system for the most part and says when someone settles, you put them on the verdict form and the jury apportions, and the defendant only pays his pro rata share of whatever is apportioned on non-economic damages. This case had a very unique procedural posture. There's no question about that. And that's what Judge Traynor was interested in, and that's what he set forth in his order. The plaintiff in this case really are the ones that want to have this both ways. They basically, we came in as soon as we could and asked to amend the complaint so that we could put Fulkerson on the verdict form. Obviously, we'd have to continue the trial to do that, but we did it as soon as we knew we had to do it. Judge Traynor denied that motion. They opposed that motion. They didn't want him on the verdict form. They didn't want an apportionment. Now, he says...
but I guess on one hand, if that's the problem, if the judge abused his discretion in not allowing you to put the other potentially liable parties on the verdict form, and if that required a continuance, then granted a continuance. If that's the problem, what about the fact that you haven't cross-appealed that?
Judge, candidly, we debated whether that was technically an issue that we needed to cross-appeal because our position on this appeal is that the judge's ruling was correct under the circumstances that the set-off ruling was correct. It was unclear to us whether it was technically something that we needed to cross-appeal or not. We believe the order that he entered, the long, well-reasoned order, we believe the set-off is the correct outcome.
Well, it appears that part of the trial judge's basis for his ruling was that the plaintiff had agreed to the stipulation, and he referenced the pretrial statement, or the pretrial order. But reading the pretrial order, it just seems that the plaintiff recognized that there had been a stipulation between two defendants. And I don't see the basis to believe that the plaintiff agreed to this stipulation. Would you agree with that?
No, sir. And if you just read the pretrial order, you will not see what you're thinking about in that pretrial order.
The pretrial order says that there was a stipulation reached between the two defendants which provided this, this, and this. That doesn't mean that the plaintiff was a party to the stipulation. He just is recognizing that that was one of the pleadings filed in the court file.
Well, that's the plaintiff's argument that their execution of the pretrial stipulation or pretrial statement was just a recognition of the posture.
What's the language you rely on that suggests otherwise?
And it's in the record on appeal, Judge.
No, do you have the order in front of you?
Yes, sir.
All right, what's the language you rely on that suggests that the plaintiff agreed to that stipulation?
It's in the uniform pretrial procedures. It's attached to the original order setting this case for trial, and they use it in St. Johns County. It's under the joint pretrial statement, which is what we're talking about. It says, to the extent the parties differ as to how portions of the pretrial statement should read, the differing views should be set forth in the statement. Now, they signed off on the pretrial statement or pretrial stipulation and never made a hint that they had any issue with the defendants taking the position that there was joint and several liability. And I believe those uniform procedures that were attached to the pretrial order, they are part of the record on appeal in this case, mandated that they do something if they were going to take the position that there was not joint and several liability. That's one of the things that bothered Judge Traynor, as you can tell from his order, that they signed off on the pretrial statement. And the other thing was this fact that illustrated it perhaps best was when we had, that morning when we were supposed to start the trial, Judge Traynor asked him, well, let me see the verdict form you've prepared. And they bring him the verdict form, and there on the verdict form are all the defendants without any apportionment. So it just convinced Judge Traynor, and I think rightfully so, that all of the parties were operating under the belief that the case was in a posture of joint and several liability. In other words, and this is what we argued to the judge for the set-off, was that the parties had effectively agreed to take this under the old law and apply the set-off that you would have under the statute. Justice Instead, we mentioned this in our brief, in his concurring opinion in the Wells case, talked about that. He said that, he was troubled by the fact that, well, we've got this new statute that says we're doing away with joint and several liability, yet we still have all these set-off statutes on the books, so what do we do? And he says in his concurring opinion that the courts are going to have to sort that out, and there may still be cases where set-offs are proper. And I submit that he correctly predicted that, and this case is very unique. They say they were powerless to do anything about our admission of liability. And I would agree that the defendants can probably admit liability and a plaintiff can't do anything about it. I do not agree with their argument that they were powerless when we admitted joint and several liability. And they say that, and Mr. Bald, I think, just argued that it's an affirmative defense that the defendants had to plead, and they can't do anything about it if the defendants don't plead a non-party's fault. Actually, if you'll read the statute, 768.813, it refers to non-parties. Non-parties. You see the word non-parties 7 times in the statute, not parties. The fact of the matter is when they sue both sets of defendants and they say both sets of defendants caused this accident, caused this death, caused these same damages, neither defendant has to plead anything about joint and several liability because an apportionment on the verdict form would happen no matter what. The only time you plead it is in a non-party scenario. We didn't have a non-party scenario until about 5:40 p.m. on the Friday before this trial was to start, and that's when we tried to put it out there and plead it. And I can understand why Judge Traynor denied our motion the morning of trial. Monday was a holiday, so we were there on a Tuesday morning on the 20th of February because it was late and we couldn't do anything about it because we just learned about the settlement. But we come back in just a couple of weeks. I think it was March the 8th before the case had been reset for trial, and we asked it again. And I submitted at that point he could very well have continued the case. Or at least continued it long enough, set it off a little bit far enough so you could do some liability discovery, and you put them on the verdict form, and we never even have a set-off issue. They oppose that. And I don't agree with the comment that they always oppose.
How could you put them on the verdict form if there were no affirmative defenses?
Well, at that point, we were asking the judge to let us amend.
Because the whole idea of Fibre and its sequelae is that if you're going to let the jury apportion damages, you have to give them some basis to apportion it. And here, everybody admitted 100% liability, right?
That's true.
So how could it would make not a whole lot of sense to put other names on the verdict form, because if there's only one set of damages and everybody admits they're 100% responsible for it, then what's there for the jury to apportion?
Well, but that was when the other defendant was party to the case. When they settled, and now they've become a non-party, they are now a non-party, Section 768.
And there's no affirmative defenses.
We asked to amend it at that as affirmative defense. We asked twice.
And was that opposed by the plaintiffs?
Absolutely. That's what I say. They want to have it both ways. It's the equivalent of us coming in here and saying, Your Honor, that not only should they have put Fulkerson on the verdict form, and we only pay our pro rata share, But after we pay that, now we want an offset for what Fulkerson settled. That's like us asking for both things. When they come in here and say, you get neither one. You don't get them on the verdict form, you don't get a set-off, you get neither one. It's the same thing as if we came in and asked for both, which would be absurd. I submit that it was a benefit to the plaintiff, and they know that was a benefit when the parties admitted joint fault, because it effectively increases the insurance coverage limits for Fulkerson from $630,000 to $1,630,000, which protects them on a skewed result at trial. If the jury put 90% of the fault, for example, on Fulkerson, they're not going to get all their damages because of the way it would be apportioned. These are all non-economic damages. That's why they were very, very happy when we all admitted fault and joint liability. It placed them in a very good position. I also wanted to point out that if you read the transcript of that hearing on the morning of February the 20th very carefully, I do not agree that they opposed the set-off. Judge Traynor, I think, was trying to sort of work a deal. Agree to the set-off, or or we'll continue the trial, whatever. I think you can read the transcript that way. But they very carefully didn't oppose the set-off. They just said, Judge Traynor, you should decide it post-verdict. He wanted them to agree to the set-off, and I agree they didn't say they'd agree to it, but they didn't oppose it either. They never said, Judge, the set-off would be improper because of this, that, and that. They just said, Judge Traynor, don't decide it now. That's the way that transcript reads. And also, at this point, they try to distance themselves from the pretrial stipulation. But if you look at the transcript of that hearing, it's in the Record of Appeal. The transcript begins, it's volume 1, page 2070, and it's on the 21st page. Actually, Mr. Pagic said this: we have relied upon the stipulation. He's opposing our request to continue the trial or get a set-off and put him on, put him on the verdict form and get us off. Mr. Pagic says, we have relied upon the stipulation by the defendant that they accept 100% of the liability of the case and do not have any Fabre defenses. It's not just an answer, it's a stipulation filed by the court. And it's in the admitted fact at the pretrial stipulation as well. So at that point in this trial, Mr. Pagic was also relying upon the fact that everybody put it in the pretrial stipulation. And now they run from it and say that, well, we were just recognizing the posture the defendants had placed the case in. And that's very inconsistent. And also, I've already mentioned that order, the uniform guidelines that Judge Traynor attached to the very first order citing this case for trial, directs them to put something in there if they don't agree there's joint and several liability. They never did. There's nothing in there. We submit that Judge Traynor was correct in his analysis. The two things that bothered Judge Traynor were the pretrial stipulation that the parties all signed and this verdict form that he could see that the plaintiffs submitted, which he knew they were operating under joint and several liability. And under the unique circumstances of this case, he was correct. Now, D'Angelo does not establish...
Is the verdict form part of the pretrial order? Or pretrial statement which y'all filed?
The pretrial order requires the parties to have your jury instructions and pretrial and verdict form ready at the start of trial.
And y'all submitted a joint proposed verdict form?
Yes, sir. We worked. It was not a complicated verdict form, as you can imagine, because you had all the defendants on one line with, because there was no apportionment. And that was done ahead of time, sometime probably the week before. But Judge Traynor asked for it the morning of the trial just to see what the parties were operating under. And the plaintiff actually handed it to Judge Traynor, and he references that, I believe, in his order in this case. D'Angelo does not establish some sort of bright-line rule that all cases with a co-defendant settling who's not on the verdict form, you can never have a set-off. It doesn't say that. And I just quoted from you earlier a provision in the case that suggests that there are still situations where you can have joint liability where there is a set-off. The Grobman case that we cite in our briefs is an example of that. Post-D'Angelo, different situation somewhat because Prudential was a constructive or derivative liable defendant that settled, but they said you got a set-off in that case. In D'Angelo, the hospital settles pre-suit. The doctor has the entire length of the litigation to add the hospital as a Fabre defendant. The doctor figures that he can blame the hospital entirely in that trial and hopefully win the case. That's why the doctor never put him on the verdict form, unlike here. Now, we asked twice, as soon as we could, to put him on the verdict form. Both motions were denied, and I certainly can appreciate why Judge Traynor denied it the first time. I think the second time it was far less compelling. But the other thing about D'Angelo that's very different is D'Angelo does not have the unique situation that we have here, where you have some stipulation between the parties of joint and several liability. There's no contention that the hospital and the doctor ever agreed to be jointly and several liable in D'Angelo, much less a pretrial stipulation like we have here. The last thing I would say is you asked the question, Your Honor, about the cross appeal, and we struggled with that, and I don't know, we didn't feel like a cross appeal was appropriate because we felt like in the final analysis, under the peculiar situation we have here, Judge Traynor's ruling on the set-off was proper. We submit if the court disagrees and thinks that a set-off shouldn't be proper, it is one or the other, then if this court should order a new trial, and we'll put them on the verdict form, like we asked for.
How could we be in a posture to do that when you didn't? I mean, you didn't give yourself that fallback position. It doesn't look to me like you did anyway. I mean,
Our position, you're right. I mean, our position was that the set-off ruling was correct.
Right.
And we still believe that, and we believe that the ruling should be affirmed on that basis alone. But if you were to find that the set-off ruling was incorrect, just like Judge Traynor was trying to do at the start of the other trial, to suggest, well, let's continue and put him on the verdict form, then we would suggest you could order a new trial. We'll put him on the verdict form. We'll try the case, have him on the verdict form, and set-off will never be an issue.
If the trial judge was correct on the only issue raised on appeal, what basis would we have to reverse on any other issue and say, but there should be a new trial? I'm not following procedurally how
well, the case decision that we cite in our briefs talks a little bit about that, where you had a situation develop at the end of that case where one of the defendants was out of the case, and the judge did not allow them to be included on the verdict form, which is, we did ask for that in this case. I think that would have been an appropriate ruling by Judge Traynor as well. He could have done either. He needed to do one or the other. I think the decision he made was appropriate, but I don't know why this court wouldn't be empowered if the court felt that the decision on the set-off was not appropriate to order a new trial and place him on the verdict form. Thank you.
Thank you, counsel.
If D'Angelo doesn't present a bright line rule, what is the rule?
Well, the problem with D'Angelo is that it presumes that you're actually going to have either a Fabre defendant or affirmative defenses or something else for the jury to apportion. See, the difficulty that I'm having with this case is there's nothing for the jury to apportion. There's damages, and everybody's agreed it's joint and several. So I'm really struggling with the notion that there should be anything other than a set-off here.
It's exactly the same as in D'Angelo, Your Honor.
Well, it's not.
Yeah, it is, because there was not a comparative fault defense asserted in D'Angelo. That means the jury would have gotten the standard instruction which tells it if it finds any negligence on the part of the hospital, which is a legal cause of damage to the plaintiff, the verdict's for the plaintiff. And that means the old theoretical 99% and 1% example that existed under joint and several would obtain. D'Angelo was going to trial under joint and several. I'm sorry.
You still get one amount. See, the problem is in D'Angelo, they had 3 years to figure out how to get on that verdict. In this case, it was essentially a day, and you all opposed it.
Your Honor,
that's what's really driving me crazy.
Well, let me give you this chronology and see if it helps. D'Angelo's decided in 2003. Wells is way back in the 90s. D'Angelo's decided in 2003, and it says if you make a tactical choice not to assert a Fabre defense, you're not going to get a set-off. 2004, after D'Angelo is the law of Florida, they make the defendants get together and make a settlement that we don't know anything about. For 3 years, there were motions, there were hearings.
You knew about it. They filed a stipulation.
We knew that. We did not know what their agreement was between them. We did not know that they had failed, apparently, to deal with what would have happened if one of them settled. You see, they were in the position to do this. We weren't. And I think it was perfectly reasonable for us, when we settled with Fulkerson, to think that the admission that had governed the lawsuit for 3 years, coupled with D'Angelo, which clearly states that if you make that determination, there's not going to be a set-off, that we're entitled to believe when we settle with Fulkerson that that is the law, and that's what's good. That's the way the case is going to proceed.
Would you agree that on day one, the time of the stipulation, they made a tactical decision to forego apportionment, right?
In 2004, correct.
Right. On day two, the circumstances changed through no action of theirs. And then they made a tactical decision that they wanted it on there, and you opposed it. Would you agree with that?
I don't agree with the time sequence. If you put in 3 years later, I think that's basically right. Day one and day two suggest this is some sort of
I know it's 3 years, but I mean
3 years and lots of litigation, Your Honor.
Okay, but the change was not caused by them. I mean, there was a dramatic change in the nature of the case in which they were not involved in, and so obviously, it's a different situation tactically. And at that time, they wanted apportionment on the verdict form, and you opposed it. And you're trying to get under D'Angelo by saying, D'Angelo says that if you make a choice to forego apportionment of a fault, and you don't want it on the verdict form, then you're not entitled to a set-off. By the time the trial judge made a decision, they wanted it on the verdict form. You opposed it. Now you're trying to say we're entitled to a set-off, or they're not entitled to a set-off because it wasn't on the verdict form. But you're the one who opposed to being on the verdict form.
But, Your Honor, the possibility of settlements happen, as we all know, in most cases. Most cases get settled. And the ones that don't get totally settled, a lot of them get settled as to certain defendants. The possibility of settlement was something that was well known to the defendants in 2004. If they're in a prejudiced position, it's because they failed to include in their agreement with the other defendant what would happen if one of them decided to settle. Why should we have to give up?
Alternatively, maybe because the trial judge improperly denied their motion to put the other defendants, which became fabricated defendants, on the verdict form, which is an issue they didn't appeal.
Well, that's true, Your Honor. I think that's also something that's within, we talk about in other arguments, we talked about standard of review. In this case, the standard of review on whether there's a set-off would be de novo, because that's a pure question of law. If the question of the denial of continuance were properly before this court, the standard of review would be abuse of discretion, and I would suggest that this court does not have the grounds to find an abuse of discretion for holding them to an agreement they made because a perfectly anticipatable event had happened. I think the court would have to uphold the trial judge's exercise of his discretion under those circumstances.
Thank you, counsel. Very well argued and both sides.